Here so we can get started. So welcome to Faith and Freedom. Thank you all for coming. And we have a few people to speak to us today. We're going to start with Representative Sondra Erickson. She's going to talk to us a little bit about the Pellsby Board. Maybe you'll do a little summary of what that is so that everyone knows, and then kind of give us an update of where we are on that. And we also have Senator Mark Koran here, and he'll be presenting a little bit too. Both of them will be available for Q&A. Now, James Dickey, our star of the show, just isn't here yet. So we're just going to pray that he got lost in the roundabout or something and he'll find his way out. So if not, we have some really good pinch hitters here. So I'm really happy that they're here. That's right. There's plenty. There's plenty to talk about. Yeah, it's all you, Mark. Yes. So, but yeah, Sondra, she has done a lot for our education. She's pushed against a lot for us, and so we really appreciate that, Sondra. Let's open with prayer. Lord Jesus, we're just so thankful, Lord, that we have the freedoms that we have here. We're thankful for the freedom of our voice, Lord. And Lord, I pray that you will be over us today, Lord, that you will bring forth truth, and Lord, that you will reveal things to us that we can take and use. And we pray this all in Jesus' name. Amen. Ta-da! The man of the show. All right, Sondra, go ahead.
You better tell him we prayed for him.
That's right.
Well, good evening, everyone. I like to use the podium because I always bring so many documents with me that I can refer to in case I get stumped. First of all, you need to know that in the state of Minnesota, we have 130 boards and commissions, most of whom are appointed, the members, by the governor. This Pellsby that Deetta referred to stands for Professional Educators Licensing and Standards Board. And everyone who serves on it is appointed by the governor. In this case, Governor Dayton and Governor Walz appointed the members. So you kind of know what their political leaning is. That was a board that we changed the makeup of and the title of and its responsibilities back in 2017 when I authored a bill with Senator Pratt in the Senate, Senator Koran's colleague, to reform teacher licensure, to simplify it, to make it more inviting to those who don't want to go through teacher prep programs, and to encourage those from out of state to get licensed in Minnesota if they want to teach in our public school system, which includes districts and charters, remember, if they want to be at the higher tiers of 3 or 4. Now, in Minnesota, you can teach in a public school in a Tier 1 or a Tier 2 without having gone through a preparation program, a college program that prepares you for how you're supposed to teach and your content you're supposed to know and to get licensed in our state. So again, Pellsby stands for Professional Educators Licensing and Standards Board and has been in effect since 2017, and all the appointees are by Governor Walz. So as you know, last time I was here, I told you about the hearing that was coming up with the administrative law judge, because these boards, all 130 of them, whether they're boards or commissions, have rule-making authority. And they write their own rules that then become what the whatever commission or board it is use as like their constitution, their framework, their basis for existence, and then they usually are in charge of someone else. Well, in the case of Pellsby, they're in charge of teacher preparation programs and licensing teachers in our public school system. And they want to revise the way these preparation programs in our colleges prepare candidates for the classroom. And this is called teacher preparation, of course. And they have, since I was a member of the former, what was called Board of Teaching, that we abolished then when we created PALSB, we created some standards that are national, that are very time-tested to be used in teacher preparation programs. So everyone who got licensed in Minnesota had the same basic standard, just like we use in our public school system for reading and math and science, and unfortunately social studies and art. But it's really important that every school in Minnesota, K-12, district or charter, has the same basic framework for reading and math and science and social studies, some of which I don't care for, but they, have the rules have been promulgated and they're used in their classrooms because they have been revised since I was the chair of education, and not because I'm not the chair, but because I always refer to time-tested standards that through the years are basically traditional and have been tested across the nation and really have the same values that our Constitution upholds. So back to the issue that I talked about several weeks ago, and the hearing, which some of you did provide comments for, and I listened to the entire hearing. There were 70 comments made over 8 hours. 8 hours that administrative law judge listened to our comments. I submitted mine on behalf of many of the members in the House of Representatives. Senator Koran's colleagues submitted comments as well. I was present on the Zoom and marked as an attendee, and it was only the only legislator or other person who was an attendee who was listed. But many, including Dieta, made comments. Bill made comments. I can't remember who else here may have made comments, but they were all very, very good. So then what happens is, after this hearing of 8 hours and 70 comments, and I have never heard of a rules revision, because that's what they're trying to do. They're trying to revise these what are called standards of effective practice that were first instituted back when I served on the Board of Teaching in the late 90s, right before I was elected to the legislature. We adopted those and put them in effect for a couple of years after that, because, we had to have rules created too. But back then it was under, Jesse Ventura, who wasn't all that bad when it came to rules. He liked time-tested. And then, of course, Governor Pawlenty following him. And it was Arnie Carlson, our former governor, Arnie Carlson, who had appointed me to the board, and then had suggested that we do have this standard across the board for our teacher licensure to send on to our preparation programs. So back to the main topic is the hearing. The hearing occurred, and then there's a time period for rebuttal. And that's a certain amount of time for comments. And as you recall, I noted that in the House of Representatives, from my caucus, the Republican caucus, we relied on statute, what's in law, and what was being violated by these revisions of the rules. And the one that was most disturbing, as you recall, is Standard 8, and they reduced them from 10 to 8, which is called racial consciousness and reflection. And of course, this brings us to that topic that's really been penetrating our society these days, that dwells on gender and race, bias, racism, ethnocentricity, white supremacy, deficit-based teaching. I mean, all these topics that are so questionable and are not time-tested. Believe me, they're not time-tested. And so that's the standard that really has aroused many of us as far as our opposition and our concern that our teacher candidates now, starting as soon as these rules are adopted, if they are, will start being taught this in our teacher prep programs. And my concern is, of course, that these are beyond the scope of what should be taught to teacher candidates to know how to teach, because pedagogy is what these standards fall under. The standards of effective practice are for how you teach. And this is going to become what you teach. Now, when are they going to teach kids how to read, which we know is really at a deficit in our state and across the nation, or how to compute their math problems? They won't have time to do that if they have to concentrate on identifying their gender, their race, or telling them, how these are different and how you might not be as good as somebody else. I mean, not directly maybe, but maybe implied. So these are of grave concern, and as I noted, the comments that came from many of you, including Deetta, focused on that. I focused on statute. So what I want to tell you tonight is that I think the decision by the ALJ will come in about 2 weeks, but I'm not as optimistic anymore that he is going to rely on the comments that I submitted, and many of my colleagues supported me and signed on to the document about violation of the statute, because in their rebuttal, and the rebuttal period ended back in September on the 19th, and so the ALJ has 30 days after that before he has to rule on this. But their rebuttal really called all of your comments, if you made comments like Deetta did, misconceptions. Oh, they're misconceptions. And then, of course, when it got to one of mine, and really we focused on, as you recall, if you do, on parental involvement. We have several statutes that rely on parental involvement. Parental involvement in selection of curriculum, parental involvement in being on advisory committees, parental involvement in having a say in what is happening in your school, in your building, in your district or charter. And they have just, kind of poo-pooed that and said, they don't mention the legislature. They just say one commentator, which of course refers to me, I'm sure. Or to Senator Pratt on behalf of the senators, also noted some things that Pelsby was not supposed to do. But that we're off track. And of course, I made comments on behalf of my colleagues and myself in regard to specific points in the new rules that I thought were being violated. So anyway, to make this a little shorter, because Deetta probably will give me the time very shortly, this is so important that we keep informed about this progress, because when we start getting teacher candidates going through program, and they then, if the ALJ rules in favor of these rules and doesn't say to Pelsby's board, you go back and do some revisions, we're going to be in a world of hurt, because this is going to be a continuation of what we constantly hear in the news, and we know is happening in some of our schools, that this emphasis is on gender and gender selection and race. And, one thing that this board did, this is a side note, just in their last meeting, was they lowered the cut score for the test or tests that candidates have to take before they can become licensed. They lowered it because they only want a 5% failure rate, because the minority candidates aren't passing these tests. And I said to my staff this afternoon as I was talking to them, can you imagine being singled out as though you're not smart enough, you're not knowledgeable enough because you're of a different color than white? Or because you have, something else that has put you in this not passing test range for getting your license? I mean, what kind of operation do we have in a tax-funded board that thinks that there's a part of our population that isn't as worthy as our white population to pass at a level that is going to tell the public, all of us, that our teacher candidates have passed the reading test, because it's a reading test, and their knowledge of teaching reading and of math. And it's basically just those two areas that they have to have an acceptable passing score in. And it just hurts me that they have made that judgment, and that's what we we will be experiencing in our classrooms, because we will have a quality of teacher who not only feels like they have been demeaned, I hope that they will recognize that and fight against this, but also that their quality of excellence in the classroom is not going to reach that level that we expect as taxpayers in our schools. So there is my summary, and as I said, I'm not optimistic, but I'm praying about this, and I hope you will, that the ALJ will see fit to send these rules back to the board, and that they will then follow his directive in how they reform them, that they will get rid of this standard 8, racial consciousness and reflection, so that teachers aren't focusing on that instead of teaching content and knowing how to teach the variety of learners that we have in the classroom. And there will be questions later, so I'll end there and hope I haven't done too much damage in overtaking my time.
Very good summary. All right. Well, James Dickey, he is with Upper Midwest Law Center. He's a constitutional lawyer, and he's been working cases in multiple places, like schools and counties, and I don't even know what else, right? So it's like a calico cat is what he works on. So come on up, James, and we're really glad that you were making. Thank you.
Thanks, Dieta. Appreciate it. Well, thank you all so much for having me here. As Dieta said, my name is James Dickey. I'm the Senior Trial Counsel for the Upper Midwest Law Center, which basically makes me sort of our Chief Litigation Officer, if you will. Doug Seaton, our president and founder, he's, I'd say, the brains of the operation, and he runs the show, and I'm a man under authority, as the Bible tells us to be. So I take my instructions, but he gives me a really, really long leash to kind of do what I would like to do and to work with him to bring cases that are the most important for Minnesotans. And I want to first start by thanking Representative Erickson for a very impassioned and very well-informed discussion of the Pellsby proposed rules. And that's the kind of leadership that we would like to see in our legislature, and we're very fortunate to have Representative Erickson there. And that's the nicest thing I can really say about Representative Erickson or Senator Koran tonight, because we are a 501c3 nonprofit public interest law firm. By law, I cannot make any statements that indirectly or directly endorse any candidate for office, whether they're Republican or Democrat, or running for the school board or running for county commissioner or anything like that. So bear with me as I am wearing the hat of the Upper Midwest Law Center tonight. And if you want to ask me my personal thoughts on things, feel free to ask me later when I'm not wearing that hat. But for now, just understand that I'm not going to make any statement. If I make a statement about a politician, it's only because I'm commenting on the legality of their efforts. So I'm going to jump into exactly what Representative Erickson was talking about, the Pellsby and the position that Upper Midwest Law Center has taken on it. But first, I want to give you a little background as to exactly who we are and why we exist. So the big question I think people ask is, well, first, like I just said, what is UMLC? Like I said, we are a 100% donor-funded, we don't charge our clients anything ever, nonprofit public interest law firm. And we exist to uphold liberty and the rule of law in Minnesota. So we take every effort that we can within the law through litigation, through lawsuits, to fight back against government abuse, to fight back against public sector union abuse, like teacher union abuse of taxpayer dollars, to fight against things like the defunding of the Minneapolis police, which I'll talk to you about soon, to fight against COVID lockdowns by Governor Walz, to fight against the mask mandate in Minnesota, to fight on behalf of people who have been terminated because they have an religious objection to taking the vaccine for COVID-19, and so on. Those are just some of our cases. But why do we exist other than to fight those cases? Well, it's because for years in Minnesota, before 2019 when we were founded, there was really, except for the Institute for Justice, which is a libertarian public interest law firm, which does fantastic work. I highly recommend you check them out, ij.org, to give them a plug. They're a great organization, and they bring great cases, but they're very narrow in the types of cases that they bring, and they're from a more libertarian point of view. And we looked at this, and Doug Seaton specifically looked around and said, you know, you've got on one side of the aisle of political thinking, you've got the ACLU, you've got groups like the Sierra Club, environmentalist groups, Minnesota Center for Environmental Advocacy, and others. And those groups all have one agenda, and it's on the far left of the political realm. Well, what we really needed was a group that could, using donor funds and not depending on people passing the hat at every single lawsuit to try to bring enough money together to pay a lawyer, $400 an hour to try to bring cases that are important and then run out of money. You needed a group that could amass enough money, have full-time lawyers to bring these cases against bad government action. So that's why we were founded. And like I said, we're only 3 lawyers right now: Doug Seaton, myself, and our newest lawyer, Dustin Lujan. We take on, as Dieta will tell you and others who have had conversations with me when you can catch me, we take on as much as we possibly can. We've got about 40 cases going right now with just 3 lawyers, plus all the different things that we do on a daily basis when folks give me a call and they say, hey, Isanti County is violating the law because they're not redistricting according to what the U.S. Census requires after every 10 years. And then we write a letter or something like that, just as an example. But, those kinds of things come and go quickly. But the cases that we're in, we've got, I think, about 40 different matters that are ongoing. So we're doing as much as we can, and the only way we can do more is if people like you support us, tell your rich aunts and uncles about us. So, keep that in mind, of course. So I want to tell you, I'm going to jump right into what Representative Erickson was talking about with the Pellsby. And in addition to Representative Erickson and others in the Minnesota House and Senator Koran and others in the Minnesota Senate, Upper Midwest Law Center also submitted comments on this. And while we didn't focus really at all on the statutes, what we focused on was the constitutional protections for people who want to become teachers or keep their license in Minnesota. And the way we look at this was there is a lot of very, very good pro-freedom case law on whether people can be forced against their will to agree with something or say something, right? It's called compelled speech. And so we simply believe that there's 2 main problems with these Pellsby rules. Number one, they do compel people to say certain things, and I'll talk about exactly what is being compelled in a second. They're being forced to say certain things. And number 2, they are putting these agreements on these topics as conditions of employment. Now, under the Constitution, you cannot have a public benefit withheld from you based on an unconstitutional condition. So you can't be forced to say, I am not a Christian in order to get a job with the government. Right? Pretty simple, straightforward thing. And in essence, that's what the Pellsby is doing to teachers. So Representative Erickson talked about Standard 8 related to racial consciousness and reflection. I want to also mention Standard 2 of these standards. And this requires teachers to, quote, foster an environment that ensures student identities, such as gender identity, are historically and socially contextualized, affirmed, and incorporated into a learning environment where students are empowered to learn and contribute as their whole selves. The requirement for a teacher to ensure that a student's gender identity is affirmed, even if they believe that there's only 2 gender identities and you are either born a man or born a woman, is requiring them. So if you are a Christian and you believe in what the Bible says, that God made them male and female, right, in Genesis chapter 1, and you are now being told in order to become a teacher, you must affirm a student's gender identity against your will. That is a clear violation of the First Amendment to the U.S. Constitution. And it's also a violation of Article 1, Section 16 of the Minnesota Constitution, which actually goes even further than the First Amendment to the U.S. Constitution in terms of protecting your freedom of conscience. So it's a really important thing that these rules get sent back to get fixed, essentially. And then they return to a semblance of what rules related to teacher training should be. What should a teacher do to be competent as a teacher? Well, they should learn how to teach, right? They shouldn't learn how to turn students into social activists, Okay, that's not their job. Their job, I mean, as was just said, you know, I think we're at what, like 36% proficiency in math and like 50% in reading and writing or something like that. It's incredibly low, and it just shows that our taxpayer-funded school system is failing in Minnesota, and this is just going to make it worse. And you all might have also heard about there's something called a teacher shortage going on right now, and it only makes things worse when you tell an entire group of teachers, well, you can't teach in public school, because in order to teach in public school, you have to violate your own conscience. It's just wrong, and it's frankly, it's not very smart. Okay, it's bad policy, and from a constitutional perspective, clearly violates the Constitution. And one thing that really irked me was when I read the response of the Pellsby originally to Foundation Against Intolerance and Racism, the FAIR group. They had submitted a comment early on back in June. And their response to them was, well, if we acknowledge that there will be some people who won't comply with our standards, if so, they should go teach in private school. It's just cold, unfeeling, uncaring, recognizing, yes, we're going to violate the law, too bad. And that's not the kind of responsiveness we want from a government agency, right? One other point I want to point out here about this racial consciousness and reflection topic that Representative Erickson brought up is that the problem with it is not that people will tell you, oh, well, what we're really trying to get at is we just want people to be able to acknowledge our racial history in the United States and understand where we came from. That is not what this is. That is not what critical race theory is either. That is not what quote-unquote anti-racism is either. What it says is that you have to understand that that racism is imbued and is in every aspect of our culture. And in order to understand something, you must agree that it is true. You can't, if they said understand the theory of anti-racism or the theory of critical race theory, my first question will be why? But the second question would be, my second point would be, well, that's not necessarily a problem because you're not requiring someone to agree with a concept that is either false and or wrong. In this case, what they have actually required these potential licensees to quote unquote understand, it says, have a foundational understanding of how race and racism are embedded in our institutions and everyday life. And it says that these standards are necessary to redesign and rebuild systems that are, quote, anti-racist and culturally affirming with policy and practice decisions. And also, it talks about that white supremacy is inherent in all of our laws and everything that exists to govern our schools and govern our teachers in the state. I mean, this is just ridiculous stuff. But it's really frustrating that teachers would be forced to agree with these concepts, that these are in fact true. And I would point out that when you hear the term anti-racism, which is kind of a colleague, it is racism. It's a colleague of critical race theory, and it really is part and parcel of the same theory. The top, I guess, like spreader of proselyte, right, the wrong kind of proselytism of this anti-racism, wrote a book. His name is Ibram Kendi. He wrote a book called How to Be an Anti-Racist. And in that book, he says that the only solution to discrimination, past discrimination, is present discrimination. So he openly says, this is a very well-known guy, Ibram Kendi. He's been, he's a star in the critical race theory, whatever you want to call it, track. He says that in order, he acknowledges we need to discriminate. We need to use our law to discriminate against people in order to basically get back at the old injustices of the past. And the fact is, in this country, there is a sordid past in this country of racist legal actions, especially in the Jim Crow South and in other places in redlining of communities. We all acknowledge that these things, in fact, existed. No one doubts it. No one disputes that slavery was real. No one disputes that slavery has long-term effects after the institution ended. But what is not right is to say that today, when you look at the U.S. Supreme Court, if you walk past it in Washington, D.C., it says equal justice under law. Chief Justice Roberts, who's, he's all right, What he said about this in a 2007 case is the way to stop discriminating based on race is to stop discriminating based on race. That's what he said. That's in the U.S. Supreme Court decision. It's like, this is so obvious. How could you not see it, right? And that is what we want teachers to learn. You know, I believe what Dr. Martin Luther King Jr. said, that we should judge people by the content of their character and not the color of their skin. And that's what should be imbued in our competency standards. We shouldn't even mention this kind of stuff. It should be focused on math, English. How do we get people to be prepared for the workforce someday and to become great at whatever they're going to do? So that's my spiel on the Pelsby, and I'll jump back into some other Minnesota-specific ones, but I wanted to just go right into it off of what Representative Erickson said, because she was absolutely right on point, and I just really appreciate that discussion. So I've been specifically asked to talk about the U.S. Supreme Court's 2022 term. But what I also want to mention is some of the highlights of what Upper Midwest Law Center has done in 2022, just to give you a quick rundown. Now, our fall update, Dieta was passing some of these out. I've got a bunch of our fall updates, which are basically give you a summary of what's happened in the year 2022 at UMLC. But one of the most important things that I want to bring up is that we filed a lawsuit in 2020 because on behalf of 8 residents of the north side of Minneapolis, 5 black and 3 white residents, who may or may not agree or disagree with me politically on other matters, irrelevant to me, because they wanted to stand up against the defunding of the Minneapolis police. Because on June 9th, 2020, 9 members of the Minneapolis City Council stood up in Powderhorn Park and they said, we are going to defund and dismantle the Minneapolis police. They signed a resolution a couple weeks later saying that the problem was the budget. And that was what they were going to take aim at. And guess what? I don't care what the news tells you. I've read 20,000 pages of documents internal to the Minneapolis police and the city of Minneapolis. And I can tell you that after that announcement was made, they cut $11 million from the Minneapolis police budget while they were dealing with massive numbers of people going on PTSD leave or leaving the force and retiring because Minneapolis had become a war zone, and those who were responsible for governing the city and governing the state did not do anything to stand up against that kind of lawlessness. And as a result of the city council's decision, and the Mayor Frey was responsible too, as he agreed to reduce the budget in 2020, we saw Minneapolis's police force go from 900 to under 600. That's a city of 430,000 people. Don't tell me, by the way, we're up here in Princeton. I live in Andover, just about half-hour south. Don't tell me that what happens in Minneapolis doesn't affect Princeton. No one can ever tell me that. And that's why I personally have some legislative ideas to refund the police everywhere in Minnesota. But I'm not going to get into that today because I don't want to go down that road right now. But what I will tell you about is what happened in this case. So we filed this lawsuit, and as part of that lawsuit, in July of 2021, we got an order from the district court requiring the city council and the mayor to refund the Minneapolis police. And then, just this year, in June, we got a decision from the Minnesota Supreme Court with 5 justices appointed by Mark Dayton or Tim Walz that agreed 7-0 that Mayor Frey must maintain the minimum police force that is set in the charter. Thank you. It was awesome because I got to argue that case on June 9th, and then because we expedited the case, we actually got a decision within 11 days, which was like never happens. And then what we did was, so now the Supreme Court's really put the pressure on Mayor Frey because the city council got out on what I think is what I would call a technicality, and there's more to come in the future, but I'm not going to go too much into that right now. But after that, Mayor Frey then proposed a budget, which is currently under consideration by the city council. And again, as I've said publicly in interviews and I've said other places, we encourage the city council to do more than what Mayor Frey has provided, but we don't know what they're going to do. But Mayor Frey provided a new budget that adds $10 million or more back in addition to additions that were made last year. And it invests hundreds of thousands of dollars into partnering with high schools to get kids more on the track of becoming police officers from the city of Minneapolis, where they grew up. It also adds over $1 million in American Rescue Plan Act funds to make the recruiting professional, right? To bring in candidates from everywhere that would actually be good police officers in Minneapolis and be able to be able to increase the force back to where it needs to go, because they're still around 600 and they need to go up. There are a bunch of other things that that Mayor Frey proposed, and so as a result of that, we looked at it. You're thinking like, so what can the court order at this point? How much more can we get? We got a solid precedent in place, and so we decided, our clients and we decided, we're going to go ahead and dismiss the case for now. We're going to let the city council and the budget process play out. And believe me when I tell you that if they try to get rid of these great improvements that have actually come about, and I got to give credit where it's due to Mayor Frey, if they try to undermine that, I can tell you our clients are not standing by and waiting for the city council to interfere with Mayor Frey complying with the Supreme Court's order. So we will be waiting in the wings in case Minneapolis decides to do something crazy. So that's one big update from us. We also are still continuing our lawsuit against Governor Walz in his based on his COVID shutdowns in 2021. So it's not 2022, but I feel like I got to crow a little bit about it. In 2021, we had filed this, or 2020, we filed the lawsuit originally, but we won against Governor Walz in federal court. So if you read the Star Tribune or the Pioneer Press, you would only have heard about all the cases that Governor Walz defeated all these challenges to his COVID restrictions. We beat him, okay? So in federal court, Judge Wright, an appointee of Barack Obama, not necessarily a conservative firebrand, came out and said, Governor Walz, our claim against Governor Walz could not be dismissed because we had stated a claim that the houses of worship, including churches in Minnesota, were being treated worse than similarly situated secular businesses like Target. So it was a huge victory for us. And of course, about less than a week later, I get a call from the Solicitor General of Minnesota saying, so do you want to talk about settlement? Like, yes, I do. I'm always willing to take an easy victory. And so we ended up entering a settlement agreement with Governor Walz back in May of 2021. And that settlement agreement is a binding document signed by the Solicitor General of Minnesota on behalf of Governor Walz. And it says that if there's ever anything like this that happens again with COVID or anything like that, that Governor Walz cannot treat churches any worse than he treats Target. Very simple, right? Thanks. So no matter what happens with other things that come up, like I was just arguing in the Supreme Court on October 3rd, just this month, on the mask case, which, believe it or not, is still going on. But the Solicitor General told the Supreme Court in that case, Justice Anderson asked the Solicitor General, so are you agreeing that you have in fact not, you refuse to give up the power to impose a mask mandate? Isn't that true? Because we've offered on the record to dismiss the case if they would just get rid of the mask mandate. If you just get rid of the power to do it, right? Saying, I won't do it again. Okay, well, in that case, the case is moot. That's what it's called in the law. It won't happen again. All right, I'll believe that if you say on the record that you're not going to do it again. Or a settlement agreement like the one we had in the Northland Baptist case. No, she said straight point blank, oh, no, Governor Walz will not give up that authority. And he would be irresponsible to do that. And so I pointed out to the court, well, it wasn't so irresponsible when they settled in our other case when they agreed not to discriminate against churches. You know, not so irresponsible there, but apparently they think this mask thing is so important. I'm not sure why. The point being that they still have to defend their case. They can't just escape judgment. They need to defend their case. But anyway, we go forward on that case as well. We're still fighting related to, we also brought suit on behalf of businesses who were discriminated against, like a gift card store shut down and Target's open next door. I'm picking on Target. I like Target. I actually like Target. My wife loves Target, so I can't be too harsh with them because they have some really good deals on stuff, and the red card gives you 5% off and whatever. This is not an advertisement. But the fact is that we have a gift card store as a client. So you shut down the gift card store, so what happens? Where does everyone go to get gift cards? They go to Target, and guess what? More people go in there. So it's like the most counterproductive thing. So we said, there's no point in this policy, right? And there's no rational basis for it. And unfortunately, we've lost so far, but we're going to appeal to the U.S. Supreme Court no later than November 7th. So we're still going forward on that case. We're going to make that appeal. The Supreme Court only takes about 2% of cases, so who knows if they'll take it, but we're going to keep giving it the old college try. One case I want to tell you about, a big victory that we had was we brought a lawsuit on behalf of 3 taxpayers to my school district in Okehennepin. And we brought it against the ISD 11, which is in Okehennepin, and against Okehennepin Education in Minnesota. Because their collective bargaining agreement says that any time they want to take a teacher out of their job teaching to go do political work for the union to support their endorsed candidates, they can do so, and the taxpayer has to pay the salary of the teacher who's out working for the union. And now what do they do in return? They give you a substitute. They say, okay, the union says, oh, we'll pay the substitute rate. Now, I loved my substitute teachers growing up, but if your kids in school are having substitutes coming in and out of class, it's disruptive. And they don't necessarily have the continuity with the students. They don't have the same feel with the educational stuff that they're teaching and everything like that. It's a problem. Point being, there's about a $400 per day subsidy to the union caused by this. And if you've got 100 hours times 40, or times 400, that's $40,000 a year. So that's just one district. Now, there's a lot of districts around the state that have this. We started with an Okehennepin. And the 8th Circuit just this year, about 2 months ago, held, whereas it had not been really clear for about 60 years now, but they reaffirmed that taxpayers to a school district in Minnesota have standing to bring a First Amendment claim in federal court against them subsidizing political speech with which they disagree. So it was a great outcome, and now we're going back to the district court where we get to have we get to fight over whether the First Amendment in fact does protect that right. I think it obviously does, that we shouldn't have to subsidize political speech by the union. And the Janus case from 2018 from the U.S. Supreme Court says so as well. But it's unknown at this point whether we're going to eventually prevail. But win or lose, we know we've gotten a huge victory, because now the federal court doors where Minnesota has, or the District of Minnesota is in the 8th Circuit. The 8th Circuit has, I think, 16 out of its 18 appointees were appointed by Republican presidents. So the District of Minnesota, while not a conservative district, is in the 8th Circuit. And so the 8th Circuit has a lot of, I think, very good jurists on its circuit. So it's really important to have those courthouse doors open because, as you all know, the judges in the state of Minnesota bench have been appointed by Democrat governors for quite a while now. And typically, while there are exceptions to this rule, but typically they tend to be more solicitous of government and less in favor of individuals who are pro-liberty and pro-government restriction. Let's put it that way. And again, like I said, there are exceptions. I'm not labeling them all the same way. Again, I just won in front of them, so I'm pretty happy about that. One bad news that I have to give everyone here is that we had a case where we got partially a good result called Energy Policy Advocates versus Ellison. We filed this lawsuit because under the Minnesota Government Data Practices Act, we believe that we had a right to know what the Attorney General's office is doing when it is hiring or when it is allowing a New York University School of Law, Michael Bloomberg-funded Energy and Environment Impact Center to put attorneys in the Attorney General's office to bring cases specifically against energy companies to battle climate change. So the office of the Attorney General in Minnesota is currently being rented out to the Bloomberg-funded New York University School of Law, State Energy and Impact Environment Center, who is paying the salary of at least one right now, it was 2 for a while, at least one special assistant attorney general, and that attorney is the one who filed the lawsuit against ExxonMobil, American Petroleum Institute, Koch Industries, and Flint Hill Resources, using the power of the state of Minnesota to do so. So our client wanted the documents, just wanted to let people know what's going on. And of course, this has a lot, because of their request, this has entered into the public consciousness a lot more. But that's not really enough. I mean, there's still a lot of documents that the Attorney General and these Attorneys General in particular are sending back and forth to other Attorneys General around the country who don't necessarily have Minnesota's interests at heart, right? It's just kind of like this just general block of people who have similar political interests. And I'm not really, interested in what they think. I'm interested in what we think. And the Supreme Court said in a partial 7-0 decision, they agreed with us on one issue, which was whether, what tests to be applied, whether those communications can be disclosed. And this is really kind of dense stuff. But the non-dense stuff, that was the really bad part, on a 4-3 decision, with a dissent by former DFL legislator Paul Thiessen, who is not exactly a bastion of conservatism, but the 4-justice majority said that the Attorney General's office can shield all data about policy matters from public disclosure. So we don't get, because Minnesota Statute 13.65 calls the data on individuals. The following data is private data on individuals. Now you would think, and I think, that if it says that the data is data on individuals, that means that the only data protected is data on individuals. The court said, no, it just means that all that data is protected as if it was on individuals. Like, head scratcher. Yeah, only a lawyer would love that kind of argument. So it's a really bad decision, and of course, the legislature can address this, and I think there could be bipartisan support in the legislature for something to amend the statute to make it consistent with the language that the Supreme Court said would have satisfied it. At least the 4 justices would have satisfied. So anyway, I've got ideas on that too. Literally, you can add 2 words to it, and it changes the whole meaning apparently. Which is not necessarily the end of the world, but right now it's really in a bad shape. And the point is, it doesn't matter who wins this year as the Attorney General. We should have our Attorney General accountable to the people. We should be able to know what's going on, not just when they're running up to election, when they're making political statements, but what's going on after they get elected. If right now this year it's Keith Ellison versus Jim Schultz. Or Jim Schultz, why would it matter if who it is? If Jim Schultz wanted to do something where he wanted to hire out the office to the National Rifle Association, people on the left should have every right to know exactly what's going on if he's going back and forth with them, because they're not the Minnesota Attorney General's office. They're not representing our interests, even if many of us agree very strongly with them on a lot of issues. But people deserve to know. Data transparency is very important to keep government accountable. So those are some of our highlights. I'm not going to go into any more of our stuff, because what you really asked me to come to do here today is to talk about the U.S. Supreme Court. And if you want to read more about us, our fall update, I've got a bunch of copies of it and everything. You can take home and you can read it. It goes through all the different stuff they've been working on, including our 2022 at a glance. So first, I'm going to talk about Dobbs versus Jackson Women's Health Organization. Now, this was the case that, on a party line vote, so to speak, overturned Roe v. Wade. Now, this also overturned Planned Parenthood versus Casey. Now, that is, in my opinion, perhaps the greatest Supreme Court decision that's ever happened, because it returned this issue. Not only did it return this issue to the states, but it also took away this concept that abortion is legal, and that it's a right under the Constitution. And so the Supreme Court held that there is no right to abortion under the 14th Amendment. Now, you all have probably heard a lot of talk about how this is just the first step, and this is going to be the erosion of a bunch of other rights that have been found under the 14th Amendment to the Constitution. Let me dispel that. I'll tell you, that is pure political talk and pure garbage. It has no bearing and no basis on what the court said. Let me read what the court said about that issue in the opinion, which apparently those who are making these comments have not read, or have read and don't tell you. It says this: so it does not undermine any precedents on same-sex marriage, homosexual conduct, contraception, or other rights. Court said this: what sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely is something that both those decisions acknowledged. Abortion destroys what those decisions call potential life. That is actually life. And what the law at issue in this case regards as the life of an unborn human being. None of the other decisions cited by Roe and Casey involve the critical moral question posed by abortion. They are therefore inapposite. They do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right, the right to abortion, does not undermine them in any way. So the court said that it was not going after the right to contraception under Griswold versus Connecticut, which predated Roe v. Wade by, I think it was like 6 or 10 years or something like that. And it was not going after Loving versus Virginia, which guaranteed the right to interracial marriage. And it was not going against the right to raise your children the way you see fit in Pierce versus Society of Sisters. It wasn't going to go after any of those rights that have been found under the 14th Amendment. And now, you may have also heard people say, well, Clarence Thomas said in his opinion that we should revisit all of these things. It's a head slapper for me, because as someone who's read a lot of Clarence Thomas, the reason why Clarence Thomas made the statement that he did is not because he thinks necessarily, and maybe he does, that the 14th, that the rights that have been found under those cases should not have been found. That is not what he was saying in his concurrence in this case. Right. What he was saying is that the rights that that the Supreme Court has found exist under the 14th Amendment's Due Process Clause should be analyzed under the Privileges or Immunities Clause. That's it. He said the same thing in D.C. versus Heller, related to guns. He said the same thing in McDonald versus City of Chicago, also related to guns and Second Amendment rights, in his concurrence in that case. He's been on a crusade for 30 years on this issue. And suddenly, he writes this thing, and you get a couple of media stories, and they say, well, they're gonna revisit everything. No, that is not what he said. And that is certainly not what he meant, because anyone who's read his opinions for decades, and I have only been reading for about a decade, but anyone who's read them for any period of time can recognize that Clarence Thomas is talking about the Privileges or Immunities Clause under the 14th Amendment. But the question for you all, and the question that Dieta asked me to address is what about Minnesota? How does that Dobbs case, how does that affect Minnesota? And I would tell you right now, it doesn't. It does not help us. Because in Minnesota, in a case called Women of the State, or Doe v. Gomez, the Minnesota Supreme Court interpreted our Minnesota Constitution to include the right to abortion within the right to privacy in 1995. And in fact, the court claimed that taxpayers in Minnesota can be forced to pay for abortions under our Constitution. In 2017, there were over 4,000 abortions paid for by your tax dollars. Now, I think there's actually a potential argument that under the First Amendment to the Constitution, you can't be forced to subsidize that. So maybe there's a way to trump that, but no one's brought that case yet. So unless the Minnesota Supreme Court overturns Doe v. Gomez, abortion will remain a constitutional right under the Minnesota Constitution. Which you've heard some politicians say, and some politicians have disagreed with that. And, I'll tell you that's the truth. Right now, there's no way that the legislature can pass laws, right? But they're just going to get struck down by the courts. And in fact, in July 2022, just a couple months ago, a Ramsey County district judge, at least for purposes of Ramsey County, whether it impacts the whole state or not, I'm not going to get into that thorny dispute at this point, threw out all of the common sense abortion restrictions in Minnesota, all of them, except there might have been one thing that was upheld. There's no longer a requirement that a minor notify both parents before getting an abortion. There's no longer a requirement that you have an abortion performed in the hospital after the first trimester. Because apparently that was a restriction on the right to privacy that we cannot have under our Constitution. And in fact, the only restriction on abortion that Minnesota had under the law, I believe, in terms of actually preventing it from happening, as opposed to just having physicians do it or having, getting informed consent and those kinds of things, was that law that said that you had to have it done in a hospital after the first trimester. Because that law was struck down, there are no restrictions on abortion in Minnesota that I'm aware of. That means abortion up to the day of birth, as far as I know. Now, if someone could show me a different provision somewhere that says otherwise, I would stand corrected, but I have not seen it. And, to the extent that, I think it's a valid question of everyone who's running for any kind of office as to exactly where they stand on when that restriction should kick in, if there should be one. But that's a question that only some people seem to get asked. Anyway, I'm sorry for the bad news on this, because it's really, it's hard to even fathom that as a father. My second daughter was born a month and change ago, and to see what a gift she is, I cannot imagine having made a decision to terminate that beautiful life. And, to me, there is no bigger issue than this one from a political standpoint, me personally. But in terms of what's going on with that case right now, just to give you a quick update, not only has so what happened after that case was decided in Ramsey County, the Attorney General's office is required to defend all the laws in Minnesota. It's their number one job. The Attorney General's office announced and decided not to defend the laws and not to appeal it. So a couple different groups have tried to do what's called intervene in the case. And in response to those attempts to intervene, the Attorney General's office has opposed them. And in fact has even gone so far now in the Court of Appeals and documents filed just a couple days ago to actually argue that because no one who was a party appealed within the time window, and of course they were the ones who had to be, that now the case is moot, again that word, and the Court of Appeals should just dismiss the appeal and be done with it. So even though the Attorney General's office lost in the decision, the Doe v. Minnesota decision that was decided in July, now they are defending their loss as tooth and nail, as hard as they can. And frankly, that's I really think that the Attorney General would have had a meritorious defense in that case and could have won that case and kept those laws in place had they continued to go through the appellate process. So from a legal standpoint, I really feel like the decision to drop the case was a poor decision as an attorney. But again, I'm not commenting on the politicians. That's why I keep saying the office of the Attorney General did this, because that's what happened. Okay, so that's the saddest news for the night. I'm going to move on to the next Supreme Court case that's important here. West Virginia versus EPA. Now, this was a huge decision, one of the biggest and most influential decisions in this term for sure. What happened is that the EPA, the Environmental Protection Agency under President Obama, enacted a new rule related to the Clean Power Plan, which is a federal law that goes along with the Clean Air Act, that basically made it so that coal-fired and gas-fired factories, power plants, right, those who create energy for us, would have to have new restrictions on carbon dioxide emissions. Now, the statute doesn't allow that, doesn't provide for it, I should say, and it's never been done before. So what the U.S. Supreme Court said was that because the Clean Air Act is so complex, and it is unbelievably complex, believe me, any rule change that changes its scope, meaning like what things it actually governs, would have to go back to Congress, that the EPA cannot make those decisions. This is called the Major Questions Doctrine. Now, that is a huge, huge deal, and it's a sea change in the way that the administrative state works in Washington. And what it means is that these major decisions on environmental issues are being returned to your elected representatives. And I don't know, is it Stauber in this right here where we're standing? Stauber here? My representative is Emmer, so I don't know which. I always get confused. The border like comes right next to my house. So your elected representative, Pete Stauber, now has a vote as to what the EPA can do. And that's a big deal. And the impact on Minnesota is pretty substantial. Not because it's going to affect what Minnesota's regulators can do necessarily, but it affects all power plants around the country, right? Because they're all subject to the EPA's regulations related to the Clean Power Plan and the Clean Air Act. It reins in the EPA quite a bit, and it will impact other EPA rulemaking decisions on other issues when they're trying to squeeze energy providers into basically not producing as much energy, which is, again, a bad idea. So there's the impact on Minnesota. I'll move on to the next case now. Shurtleff versus City of Boston. Now, this is one you probably have not heard of, even if you've heard of the other ones. This is a case where the city of Boston had a policy. They allowed private parties to fly a flag up on the city flagpole in the town square, right there in the middle of Boston. And they allowed everyone to do it until someone said, I would like to fly the Christian flag. Come on, right? I mean, this is ridiculous. And the Supreme Court agreed that it is ridiculous. And in a 9-0 decision, held that where the government opens up a forum to speech, such as a flagpole, for private citizen speech, it cannot discriminate based on viewpoint. And especially it's true because there are other flags they had allowed up. I think they had allowed the moon and the crescent star, or the crescent and the star flag for a Muslim flag as well, or maybe it was like the flag of Turkey or something like that with the crescent and the star. And the court pointed out that every viewpoint has been welcome up until someone wanted to fly a Christian flag. And the Christian flag, I'm not even sure, I think it's that one, right? So I think that's the flag that they wanted to put up, and the city said no. Anyway, it's bizarre. But this actually has a big impact directly on one of UMLC's cases. So I was really happy about this decision. Last year, we sued the Lakeville Public School District because they allowed private citizens, made all this input, and they did all this stuff, and then Lakeville Public Schools approved of a poster series that include posters that say Black Lives Matter on them. So our clients simply said, well, hold on, okay, if you have those up, what about like flags that say All Lives Matter or Blue Lives Matter too? And the school district said no, because that would undermine Black Lives Matter. And so we are going to let Black Lives Matter posters up. Teachers and students can put those up in the classrooms and the hallways, but you cannot put up anything that says All Lives Matter or Blue Lives Matter. The answer is no. So we sued them. We lost on like technicalities, and one of which was a grounds that was reversed in that Huizenga case I told you about with the school district taxpayers. So we actually lost 2 cases on the same ground in the district court. The Eighth Circuit then reversed on the same ground, and we let the case go because we decided to refile it without going through the rigmarole of an appeal. But if we had kept the case going, we would have won on appeal, which is, you never know when things are going to work out like that. But this shirt lift case is important because what the school district has claimed in our Lakeville Public Schools case is that they, as the government, have a right to speak, which they do, and that this poster series is quote-unquote government speech, which is not subject to the First Amendment. Now, the fact that when government speaks, it is not subject to First Amendment restrictions. They can adopt affirmative statements that are the government's official viewpoint. Like when the U.S. government says, "In God we trust," that's government speech. The U.S. government can do that. If Minnesota says "La Toile du Nord," that's government speech, right? If Minnesota says that the policy of Minnesota is X, Y, and Z based on a legislative law that was passed by the legislature, they can do that. Okay, but what you cannot do, and what Shurtleff says you cannot do, is allow private citizens to have a higher position than other private citizens when you open up government property as a forum. So for example, if you have a school board meeting and there is a time to talk, you cannot discriminate between 2 different speakers based on their viewpoint if you open it up. If you don't open it up at all, it's a different story, right? There's not necessarily a right to speak at school board meetings, just so everyone, that's one important issue that I know people are always worried about. It's a fact that if the school board doesn't want to open it up, they don't have to. But but once they open it up, then they have to give equal viewpoints. Same thing in Lakeville with their posters. These posters were purely created by private actors, right? They were all the input. There was like one thing that the school board changed and approved. So in our opinion, they simply have to allow other private actors to have the same right to speak. And that's it. We're not asking them to pay for anything or anything like that. They just want to be able to put up those posters, and they want teachers and students to be able to do that too. So we think the Shurtleff case, Shurtleff versus City of Boston, U.S. Supreme Court will actually have a big impact on our case in Minnesota, and we're looking forward to going forward on that case too. I also want to tell you about the New York Rifle and Pistol Association versus Bruin case. Now, this was a big Second Amendment case written by Justice Clarence Thomas over this summer. New York had a state law that required that allowed you to have a concealed carry permit only if you could prove you had a special need for it. Now, what do you think that regulators in New York are going to consider to be a special need? Their opinion, my opinion on a special need to have a gun is that I want it, right? That's about as all I need to know because I got a Second Amendment, okay? But they, of course, so the point the court made, the court struck down this law. They said that you can't have restrictions like that on the right to carry because you have to look at from the history and tradition of the Second Amendment at the time of the founding, and because of the text of the amendment, which says the right to keep and bear arms shall not be infringed. What does bear arms mean? It's not actually an animal in the woods going like this, okay? So the fact is you do have a right to do that. There's no way that you can't be allowed to get a concealed carry permit as long as you don't go afoul of any particular federal laws that make it illegal for you to carry. So, for example, you can't be a felon in possession, you can't be an illegal alien in possession, so on and so forth. Those are some restrictions that the court has upheld. But what does this do for Minnesota? Not too much right now because there are no special need jurisdictions in Minnesota. Right now, I think every single county and sheriff in Minnesota must, under state law, issue a concealed carry permit with, there's one carve out in case there's a real problem. And I'm not sure exactly what the language of that statute is off the top of my head. But this is a big deal because it is it stops bad actors in the government, in the localities and municipalities and counties who may want to restrict how many. So if the Hennepin County attorney decides, you know what, I hate guns, so I'm just going to, issue a new policy that says that we're only going to issue upon a special need. Can't do that. Obviously, they lose under the Second Amendment because of the Supreme Court decision. So it is good in that way because it protects our Second Amendment right against intrusion in the future, even though it doesn't strike anything down as we speak. I'm going to move on to Kennedy versus Bremerton School District will be the last case from the term that I'm going to specifically focus on tonight. And of course, if anyone has any questions about other cases that I may or may not have read, you can ask. And I'll tell you what I know. But in Kennedy versus Bremerton School District was about a football coach who prayed at the 50-yard line after games. You all know Coach Kennedy, probably seen really good stuff if you've ever gone on, I think it's First Liberty is the law firm that represented him. They have great interviews with him on Fox News and stuff like that. Very cool stuff. Really nice guy from what I can tell. He just went out on the 50-yard line, would go pray after games as a sign of gratitude to God and wanting to give glory to him. And some of the players would join, but it was their voluntary action. He was fired for that. He was fired because he prayed at the 50-yard line because the school district claimed, oh, no, we can't have you do that because it might look like the school district is endorsing religion. And that's a violation of the Establishment Clause. We're afraid we can't do that, so we're going to fire you. Well, the U.S. Supreme Court disagreed with that decision. And they held that this violated his First Amendment rights. This termination violated his First Amendment rights because his prayers in the 50-yard line were not within the scope of his job duties. As a football coach, the game was over. He didn't have duties immediately back in the locker room. He wanted to go out to the 50-yard line to pray. They said he can go ahead and do that, and that's not necessarily indicating that the school district is endorsing religion. And what the court said was, to the school districts especially, stop with your quote-unquote fear of, oh, we might be establishing religion if we allow someone to make an individual decision to express their faith. That is not what the First Amendment is all about. There's not kind of this Establishment Clause on one side, Free Exercise Clause on the other side, with no room in between. In fact, the Establishment Clause only relates to the actual establishment of religion. So historically speaking, and in my opinion, and also Justice Thomas, who happens to be my favorite, as you can kind of tell, in his opinion as well, the meaning of the Establishment Clause was actually just to prevent Congress from coming in and stopping and establishing religion. Because at the time of the founding, Maryland was a Catholic state, for example. Pennsylvania was a Quaker state. It still is called the Quaker state. And I think, don't they have automotive oil too? Anyway. And then maybe some cereal too, but not Quaker state, but Quaker oats. But anyway, the point is that there were religious states at the time of the founding. So this concept, this whole thing of a wall of separation between church and state is totally not within the original understanding of the First Amendment. This was based on a letter written from Thomas Jefferson to the Danbury Baptist Church in Danbury, Connecticut, back in, when he was president after the amendments were adopted. So, it's kind of like a gloss that has been put on the First Amendment over time. And the Supreme Court with this decision really is kind of walking back towards the traditional understanding of the First Amendment. Now, they are not going to end up saying that Minnesota can adopt Christianity as its state religion. We're not going to go back there. We live in a pluralistic society. It's just not going to happen. But it does mean, especially municipalities, school districts, localities, and government employers too, they need to allow people within their own private sphere, knowing it's not interfering with their job duties, right, or putting their employer in a position where there's a problem. They have to be able to express themselves on a religious basis, right? And I think that is just consistent with a pluralistic society where people have a lot of different religious beliefs and they express themselves differently in a lot of different ways, including, by the way, I would argue that if you forbid anyone from expressing their religious beliefs in a public setting, you are endorsing atheism as a state religion. So what about that as an establishment problem, right? And in fact, if you ever want to take a look at our very legalese comments in the Pellsby that we were talking about earlier, we actually argue that this use of these new standards that they're creating, whether it's affirming gender identity of students or whether it's saying you have to agree that white supremacy dominates the United States' laws, and that there's kind of like this liturgy of like, oh, let me kneel and do my penance for having been born white. I'm so sorry. That this is actually a religion. So we are also going to, if these standards are adopted, by the way, we are going to file a lawsuit. Okay, we're not. I can tell you that I don't know who it's going to be on behalf of, but I can tell you there are enough people really upset about this and we believe that because it violates the Constitution, it should be litigated. Now, I don't know who's going to join us in that. We ideally would have like a teacher join us as a plaintiff. Perhaps there are religious universities across Minnesota which have a Christian viewpoint and don't want to train their teachers to agree with what these standards say. Those might be a potential plaintiff as well. But I will tell you, it's unconstitutional, so I think it's going to fall. Whether it falls under Minnesota state courts or whether eventual appeal to the U.S. Supreme Court is in order, because you have a right to appeal to the U.S. Supreme Court if your claims invoke federal legal issues. Even if the Minnesota Supreme Court disagrees with you, you get one more step on those. So, for the Kennedy case, though, it's a great decision. It really restores the original meaning of the First Amendment, and it just shows that this court has done nothing but walk back some of the terrible precedents that have taken place over the last even 50 years. It's been a really great term for the rule of law, and I'm looking forward to this next term as well, which I think is going to be amazing. I think it's going to end up with some great precedent as well. I think this court is well on its way to being probably the most influential court in the last 25, 30 years. Now, I want to say, in terms of impact on Minnesota with the Kennedy case, if there are any public employees or teachers in here, there's no way that I'm going to be able to answer specific hypothetical questions that you might have. And I just want to say that because every case is going to turn on its facts, right? And the question of whether someone is doing their job duties during a certain activity or not is going to be a difficult one to tease out and requires a lot of research into different cases, into how things have come down on different issues. So just bear with me while I think that the impact here is that a teacher's religious exercises in a school setting, they're not coercive on students. They're protected by the Free Exercise Clause. A school cannot ban religious expression just out of fear that someone might claim it's an Establishment Clause violation. So that's the U.S. Supreme Court's effect on us, and I don't know if I have time, but I also have more stuff I can talk about with Minnesota-specific issues. Okay, I'll keep going. You guys awake still? We good? Everyone's good? All right. I don't want to put anyone to sleep. So I'll keep modulating my voice up and down, up and down. We do jumping jacks if we have to. So I want to talk a little bit about curricula and standards. This is in schools, and this is a really big issue to a lot of people. And we have come across it not so much in actual cases, but we've done Data Practices Act reviews, and we've gone around the state, helped parents to get data related to what's going on in their schools and that kind of thing. And we get a lot of questions from people. And by the way, before I forget, We do have a parental rights toolkit on our website, umlc.org, and our handouts have all our website on there. If you're interested in how data practices works and how you can ask for data from school districts, you can look on our website. We've got basically a toolkit that says, here's some generic guidance, because we can't actually give legal advice in these things because we don't want to create an attorney-client relationship without actually having a conversation. But it also provides like a sample form, like how you could ask for data in a particular manner. And it also advises, for example, don't make a request that's super broad ranging that you can't follow through with. You're going to end up having a million pages of documents that you can't possibly go through, and that just waste taxpayer dollars on them turning over documents that you don't want, right? But there are good reasons and good ways in which you can make these requests, and we've learned a lot about this over the last couple of years. Oh, thank you. Oh, keep that there. Much appreciated. Now, school boards control curriculum. Okay, that's just, I want everyone just that is, so the state does not. The school boards control the curriculum in schools. The State Department of Education and the legislature control standards. Now, the Department of Education controls them through rulemaking. I cannot possibly cover all the reasons why the proposed social studies standards are terrible in the time I have here. I would just refer you all, if you want to learn more about what is happening and changing our social studies standards, which, by the way, have been praised as a time-tested model for excellence since the 2004 standards were originally created across the country, and they've turned it into a thing where kindergartners are learning how to be social activists. I couldn't even begin. I know that Representative Erickson was at a recent CAE event that I also attended, where it was Wilfred McClay, I think, who spoke. And American Experiment, AmericanExperiment.org, they put on amazing stuff. Katrin Wigfall and Kathy Kirsten there, they do so much good research to let people know what's going on with these standards. And they're the ones who had that Raise Our Standards tour last year. I can't recommend enough that you just go to their website if you want to learn more about what's going on with the social studies standards. But I can tell you from having read through a lot of them, not all of it because it's long, and I don't really want to read a whole thing until I have to. But I can tell you I've read enough to know that there's problems, and that they're going way beyond the actual statutory mandate. And again, as the rulemaking proceeds, they're in the rulemaking process, there will be another opportunity for legislators and other interested people to weigh in on those standards. So I encourage everyone to keep an eye on the rulemaking process related to the social studies standards and weigh in. But I want to also point out that the standards themselves do not require certain things to be taught in curriculum, okay? The school boards still get to choose, for example, what books would be used in order to implement the standards. So the point is that the standards are kind of like a guidepost that schools have to go by. They have to make sure their students learn certain things. And the curriculum are the vehicles that are then driving past those goalposts or those guideposts to figure out, or to help students actually get to where they're trying to go, their destination. So that's the way that way that I would think about it. I would also note, so I'm in an Okehennepin school district down in Andover. And like my school district, your school district is likely going through curriculum proposals right now, anticipating that these social studies standards will be adopted. And I don't care where you are in the state. If there have been people who have been running the school boards and local governments in Minnesota for decades now, before 2020 came around and people started realizing that what was going on in their local government really matters. I will tell you that you should be involved in this process, because you would probably be shocked at what's going on locally. I get emails that summarize exactly what the committee, the district advisory committee, which I encourage you to join if you can. It may be too late right now for this year, but I encourage you to join in case there's like a rolling opening. It's statutorily required. A certain number of parents have to be on it, and you get a say in what goes into the curriculum. Okay? I recommend you get on that, because I will tell you that the anticipation of the social studies standards is leading an Okehennepin to be recommending all kinds of anti-racist material, things that are, again, claiming that white supremacy is in everything, and it's the same thing you see in the Pellsby stuff. It's happening at your local school level, and I've already provided comments back to the committee myself saying I really think that you're going to lead people down a road that you don't want to go down, and you're potentially going to violate the law doing this. So I recommend that you do the same. One of the things that I also hear a lot about is about library books and what should be in libraries and schools and in public libraries, and also like how to address curriculum issues when they come up. There is a state statute that allows you to potentially propose different books, for example, to be used in the education of your student in public schools, but you have to go through a specific process in that statute. I think it's 120B point. I can't remember the exact statute. I didn't write it down. But take a look. You can review some curriculum as a parent, but once your school sets a curriculum, it is going to be nigh impossible to change that except through the school board. Okay? So there's really not going to be a way, unless the curriculum is just beyond the pale, to have any way. And in federal courts, where again we're most friendly audience on these kinds of things, they don't want anything to do with curriculum. And they have made it clear that school districts have a broad scope of work that they can kind of maneuver within for curriculum. So it's important to make sure you get it right up front, and not come in after the fact and say, hey, this is wrong. Well, yes, but needed to take care of it up front. Same thing with our election laws, right? It's one thing after the elections happen. It's almost impossible to fix problems after the election. Before the election, you can do a lot of good. So books in the library and books in the library too. I will tell you that there are so many that courts are very, very pro-library. They're not going to remove a book from the library unless they absolutely have to, because removing books feels like book burning, and they don't want anything to do with it. So unless there is an obvious example of obscenity, meaning pornographic material, you're not going to end up getting a book removed from the library. So that's an important thing to certainly recognize. The best bet for removing things from the library is to go through the political process. Your county boards are the ones who hire the librarians, right? And get people who are working in these positions who will reflect your values. That's my best advice on that. The political process is the way to go. Let me see. I've got a couple more things for you, I think, but I'm getting close to the end here. Yeah, so one other thing I wanted to talk about, last thing I'm going to mention tonight, is school board policies. So we have noticed recently, and the example I'm going to give is White Bear Lake. Has anyone heard of White Bear Lake's new policy? White Bear Lake has now issued a policy guidance to Policy 413. I think it's like Appendix C of 413. And it says at the very end that employees, including teachers and administrators, that if they refuse to use a child's preferred pronouns, they can be fired. Now, that's, again, compelled speech, right? I already talked about how you can't do that for licensing. This is a violation of the law. I can tell you, point blank, this is illegal. Now, that's, again, if I were the judge, it would be an easy case. In the Sixth Circuit Court of Appeals, which governs like Ohio and Kentucky a little bit east of us, they have a case called Merriweather versus Hartop that was decided a couple of years ago by Judge Thapar, who was a Trump appointee. And he said that a college professor could not be forced to use a student's pronouns that they preferred. That's college, though. K through 12 is always more deferential to the government. So it's an open question whether this kind of policy will survive. But regardless of the obvious difficulties the school district faces in adopting this policy, they've done it anyway. And I've heard rumblings in other districts that this is in the works as well for them. And so I think you just want to keep an eye on your school boards, on their policies that come out when they get adopted. Be involved in the political process is my best advice, because the law can fix some things, but you can fix so many more things by actually being there and showing up. And I think it was Henry Ford, right, who said that showing up is how winners are made. The last thing I'm going to mention, and by the way, if there's a teacher in White Bear Lake that you know, or someone who doesn't like the idea of having to violate their own religious beliefs in order to uphold this policy, we, of course, would love to represent them in a lawsuit against it, and we'd love to have this enjoined. We'd love to make an example of it so that other districts around the state stop doing this kind of thing. You've also probably heard, speaking of school districts, of the Minneapolis School District's illegal collective bargaining agreement with the teachers union there. And so I actually got a chance to go on Fox News and do a couple interviews with them, and I actually had one with Good Morning America, which is kind of weird. And it was very strange, but because we don't actually have a lawsuit over this. But I got quoted in an Alpha News article because I talked to the folks at Alpha News about this, and they're like, they're doing what? Oh, man, come on, guys. But they're a great organization, too, by the way. I love them. And they also host our podcast, Minnesota Law Weekly, if you're interested in. It's like a 5 to 8 minute podcast. I give an update every week as to what's kind of going on with our cases and all that kind of stuff. Go on Alpha News, click podcasts, and it's one of the 3 podcasts that are there. But what this bargaining agreement says is that if you are a white teacher, you get fired first. What? Right? I mean, it's just absurd. So I got interviewed on this, and they said, so you've alleged that this policy is illegal. Why is that? Well, you can't discriminate based on race. That's the easiest interview I've ever done. So. The point here is that what the policies are designed to do and what they are attempting to do, to give them the fairest benefit of the doubt, what they're trying to do is because they have a belief that in order for teachers to be effective, they must reflect the race of the students they're teaching. Now, they claim that there are studies that support this. I tend to think that good teachers are the teachers that teach best, regardless of the color of their skin. I think that every student is actually owed that. I think every student in Minnesota is owed the attempt to get the best teachers possible, not teachers who look a certain way. So the problem with their argument is that it goes directly in the face of U.S. Supreme Court precedent from 1986. And this has been the law for almost 30 years now. It says that, or is that more than, no, I was born in 84 and I'm 37. That's more than 30 years. Wow, that's old precedent. I know because I'm older than it. But anyway, that case was decided, and they said you cannot use race as the determination of whether to fire someone. Duh, right? It's so obvious. Now, if you have evidence, so this is where this case is works perfectly with Brown versus Board of Education, because if you have evidence that there was a racist policy in place by that school district, so for example, the Board of Education of Topeka, Kansas, that segregated students. That is a racist policy. That can be, that can't happen, right? And so you can have a policy that changes that, a busing policy that desegregates. You could have that, and that even if that results in, changing the demographics of the school intentionally just based on race, that's okay under the Constitution. But what you can't do is simply say, whites need not apply, right? You can't do that kind of thing. And then this, of course. I'll end with this little bit. In this Supreme Court term, a lot of these policies in other school districts, because Minneapolis is not the only one with this policy. I know the news is only focused on them. Robbinsdale, St. Louis Park, and Sartell, I know for sure, have this policy in a different wording. And what they say is, in order to implement our affirmative action policy, in which we attempt to hire more teachers of color, more ethnic backgrounds, in order to increase diversity in schools, we are not going to fire other teachers. We're not going to fire teachers of those races. We're going to fire white teachers first because we want to make sure that we're keeping up with our affirmative action policy. That's a more creative way of putting it, frankly, but it's still, you run into the same problem. You're firing people based on race. And I just think this, there should never be a law or never should be a bargaining agreement or any other policy of any school in the entire country, and especially not Minnesota, that says, if you're white, you get fired first. If you're black, you get fired first. This is just ridiculous. These people, if they can get past the Pelsby and the standards and get licensed and get a job, once they're there, if they're the only thing that really makes sense to me is merit, right? And the school districts have come back at this and said, well, the problem is we have a seniority system that makes it so that all these new teachers of color that we're hiring get fired first. Well, get rid of the seniority system and go to merit. Common sense, guys, and this is just another common sense solution. But again, right now there's already a lawsuit against them. We didn't file it. Judicial Watch out in D.C. filed it, and they filed it in state court. I hope the best for them on that. I think that it's better cases to be brought in federal court with an actual teacher in Minneapolis who may potentially be on the chopping block, and I think that lawsuit you're going to see once the policy kicks in next year. So I can't say whether or not we'll end up bringing it, but I know that we are certainly interested in bringing that lawsuit because I just think that, you know, there's nothing worse in this country at this point in time than race discrimination. The policies and the laws that divide people up instead of uniting people are just, they're just evil, and they're a waste of our time, and we should be focusing on how to make America the best country and Minnesota the best state that we can. So Upper Midwest Law Center, all of our actions and efforts are intended to promote freedom, promote the rule of law, stop government overreach, stop public sector unions from harming their employees, to stop race discrimination, all these kinds of things, to make our schools the best they can possibly be. We try to find creative ways to uphold the law, to enforce individual rights against all of the things that we see as problematic when government takes bad actions or when private employers do. So I want to thank you so much for letting me speak. Again, we are 100% donor funded. We get donations from hundreds of people across Minnesota through the grassroots. We don't charge our clients anything for any work that we do. So we can't keep doing what we're doing unless we have help from like-minded folks like you, and especially your rich aunts and uncles. So we appreciate anything you might be able to give us. I've got donation envelopes with me that I can leave out on the table out front. But thank you so much for supporting us. Thank you for letting me speak here about how we're fighting for Minnesota's liberty and the rule of law in the courts. Hope I didn't go too long.
Thank you. You did great. Dealing with, yeah, we'll do questions and answers. We're going to give a 10-minute break, and then we'll let them come after you. You did an excellent job of taking a topic that can be extremely boring, because talking about law stuff can really get like, it's like, you did a good job. You did a good job. All right, we're going to give you a 10-minute break, and when you come back in, just remember a couple things. We'll lay the rules out now. No open container of drinks or something that can spill and get on the floor. You know, make sure it's got a lid on so it's not spillable. As far as questions, we're going to, again, use the roaming mic system. And everybody, we're going to try to get everybody one question before we start giving one person multiple questions. Sometimes one question has like a part A or part B to it, where you have to follow up a little bit with the answer. We're good with that. But a whole new topic, you're going to have to wait your turn until everybody at least had one question. So I think you pretty much all remember the rules. So let's take a quick break and come back in 10 minutes. We'll do this.